Maybe Lordships. Lordships, I beg to mention item 18, Lordship. I'm for the appellant, Lordship. Lordship, it's a matter of after the vacation, Lordship.
On the prayer of Mr. Oseko Photo, Learned Counsel for the appellant. List the case on a date, list the appeal on a date immediately after the ensuing winter vacation. It's submitted that Mr. V. Jimomi, Learned
PP.
Public Prosecutor, is in attendance.
Obliged.
May I please, your lordship? My lord, I pick the mission item number 2.
2.
Yes, my lord. The
Yes.
test matter will come up next. What they say, my lord? Item number 2.
Preventive detention.
Yes, yes, my lord.
Lordship, the detainee is, the detention order has been passed on 30 May, Lordship,
Okay.
and it's pending till this, so I pray that the matter be taken up.
Monday then?
Yes.
Monday?
What they say?
We'll sit in revision bench.
Yes, there is a different bench of the witness.
No, instead of Wednesday, we can sit on.
My lord, actually, my draft contract effectivity is not yet conveyed for. I have sent for waiting, my lord. And similar prayer for item number 3 and 4, my lord.
The council, these are habeas corpus matters.
Yes, my lord.
When this court has, the matter has to be taken up with urgency. We are accommodating you today. We'll have it next week on Monday. Or 1 or 2 matters on Monday and 2 matters on Tuesday. But these are habeas corpus matters.
May please, Lordship, my lord, let the matter be taken up on Friday, this Friday, not Monday, my lord.
This Friday.
Next week, I have difficulty, my lord.
Which one?
Item number 2.
Item number 2.
Yes.
And he is asking for
Next week, my lord.
week.
Yes.
We check consensus.
Next week, I won't be available, so my lord. I'm going out, my lord.
And over a brief to somebody else.
Okay, then.
Otherwise, it is preventive detention.
Yes, my lord. Yes, ma'am.
My lord.
We can put it on Monday or Tuesday.
My lord.
Monday. Okay. In item 2,
Yes, and item 3 also a similar prayer.
counsels are different. Mr. V. Siri,
Lord.
Learned Counsel for the petitioner. Mr. N. Gully,
Yes, my lord. That and only.
Z. N. Gully, Learned Central Government Council. And Mr. V.
E.T. Bapom.
E.T. Bapom, Learned Public Prosecutor for the state of Nagaland. Are present, full stop. As sought for, Mr. Nguli, you file your affidavit before that.
My lord, I'll try.
Mr. Nguli, Learned Central Government Council has submitted that he is yet to file the counter affidavit and will make endeavor to file the counter affidavit on within this week. Full stop. As sought for by him, lays the case on Monday. And who is in item 3?
My lord. 3 and 4.
3 and 4.
Yes, my lord.
You are Mr.
Yes, Sophie, my lord.
A. Sophie, okay. Central Government and J. Anguli and Mr. N. K. Angami, Learned Additional Public Prosecutor present. Same thing, N. Gully will make endeavor to file counter affidavit. As sought for by Mr. N. Gully, lays the case on Monday.
Most pleasure.
Please, your lordship.
4 is Mr. Sophie, you are there.
Yes,
Item
my
number
lord.
4.
Yes, my lord.
Item number 4 is on Tuesday.
Tuesday.
5.
3 and 4 both are co-accused. If they, these two matters can be clubbed together.
Lordship, in that case, Tuesday, 3 and 4, Lordship.
Okay. Then we'll put
Very
3 and 4 on Monday,
Okay.
2 on Tuesday.
Very good.
Item number 5 is also an NSA matter.
Mm.
Lordship, in this matter, I'm yet to file my affidavit. I'll be filing in the course of the day. So
Okay.
if the matter can be listed next week.
My lord, I object because the detention order is expiring on 13th. So in the case of Chikurumani versus State of Andhra Pradesh, adjournment was not allowed because the detention order was about to expire. So I pray before Supreme Court to kindly dispose the matter today. Since the state government, they always pass the extension order 1 week before the expiration of the order
When it is going to expire? 3 months?
on 13 December.
13 December.
Yes, my lord. And the detainee has been for almost 1 year. He has been detained for almost a year.
Maximum is 1 year.
Yes, but in a similar case, Supreme Court have decided that a detainee must not be detained up to 1 year, 12 months, in exceptional circumstances. But here, no public order was disturbed. No public life or community life was affected. It's only individual crime. So there's a number of cases where Supreme Court have passed adjustment. So and the state have been given enough time.
So you're going to file today?
Yes, your lordship, we'll be filing in the course of the day.
We'll take it up prior to 13th and dispose it out prior to 13th. Your only anxiety is till 13. 13 is the last day.
Hmm.
Take it up on Monday,
Monday?
next
My
month,
lord,
coming Monday.
Coming Monday. Mr. Paki in Richabu, Learned Council Board of Petitions is present. Mr. MS Mary, Learned Additional, Learned Public Prosecutor, has submitted that the counter affidavit on behalf of the state will be filed during the course of the day. List the case on Monday for final consideration of the petitions. You bring all the records
Lordship.
in,
Yes.
in all the cases.
Yes, lordship.
All the other matters also.
Other matters, okay.
Get the
Yes.
records, huh? These 2, 3, 4.
5.
I'm
my
obliged.
lord, if in case state passed the extension order before 9, my petition will become infructuous.
No, your statement is that 1 year is going to expire on 13th.
Yes, but the state always
It
pass
is-
extension order 1 week
It is
before
under
the.
which act?
No, the practice of the state government is that they always pass extension order a week before the expiration.
Detention order is under which act?
NSA, my lord.
NSA.
Yes, ma'am.
What is the maximum period of detention?
12 months, ma'am.
Huh?
12 months.
12 months?
Yeah.
Or 2 years? NSA?
1 year. Yeah. It's only 1 year, my lord.
1 year. Initial 3 months.
Other cases are under PIT NDPS Act.
Yes, my lord.
2,
Some are-
3,
some
4.
are in NSA. Some are NSA, some
No,
are.
2, 3, 4.
Three, four P then it is.
PIT NDPS. 3, 4 PIT NDPS. And item number 2,
Item number 2, PIDS and
Yeah.
DVSs.
Section
NSA.
13, 12 months.
Huh?
Under section 13 is 12 months. The maximum period for which any person may be detained in persons of any detention order which has been confirmed under section 7 12 months from the date of detention.
so how it can be extended beyond 1 year?
But here the question is, if the detention order is not revoked, he will languish in jail in custody. So my prayer is to revoke the detention order.
We'll have
Monday.
it on
9th.
Monday.
May it please your lordship. Lordship, I'm appealing to VC, your lordship.
Yes.
I beg to mention item number 19, your lordship. The matter on the last date, there was no fixed date, lordship. So the matter came up Sunday and we couldn't come, lordship. May I plead the matter may be adjourned for the day, your lordship. Item number 19, your lordship.
19. You have informed the other sides.
I have informed Mr. Idalu, your lordship. Only thing, lordship, may I pray for 29th of Jan, lordship, as a fixed date, your lordship. We'll come down to Kohima, lordship.
Mr. N. Gautam, learned counsel for the petitioners, has made a prayer for adjournment. Come out with the consent of the learned counsel for the other sides. So, as sought for by the learned counsel for the petitioner and as agreed to by the learned counsel for the other sides, release the case on 29/1/2025.
Lordship. Oblige, Lordship.
Lordship.
You're there.
Yes, sir, for 2 and 3, Lordship.
May it please, my lord. Lordship, hearing item 17, if it can be passed over for the day and taken up tomorrow, my lord. I have also taken the consent of the PP and the amicus, my lord. It's a criminal jail appeal, lordship, pending since 2022.
Next Wednesday. Next Wednesday.
Next Wednesday, my lord, my lord.
Okay.
Much obliged.
On the prayer of Mr. Saint Anger, learned counsel for the appellant, place the case appeal on
11, 12.
11.
Much obliged.
May I please, Lordship, with sincere apology, my lord, today, last night I've overlooked the cost list and I could not bring the file of item number 8. Yes, so
May it
Let-
please your lordship, I am on VC. In item number 8, I am the petitioner in this matter. So last time also this matter could not be taken up. This is a habeas corpus matter. 6 months have already passed. So I cannot say whether if he has, he forgot, he said he forgot to get the file.
yes, let the matter be passed over, might not, the matter be taken up tomorrow also.
Tomorrow, I have some difficulty tomorrow. Can it be day after tomorrow? In that case.
Tuesday then?
Next Tuesday.
Yes.
Okay.
8th of December.
Yes. Lordship.
Mr. Y. Mandan, learned counsel for the petition, has appeared through video conferencing mode. Also, Mr. E. Thibapong, learned public prosecutor, has made a prayer for adjournment and to fix the case on Tuesday, 10/12,
Lordship.
24.
Much obliged.
Leave the case accordingly on 10/12.
Produce the records.
Okay, my
Get
lord.
the records.
Everything raised.
Mr. Thibapong, learned tradition for learned public prosecutor is to produce also to is required to shall keep the records in readiness on the next listing.
Much obliged.
Obliged, your lordship.
Lordship, I'd like to mention hearing item number 13, 14, and 15, your lordship. Lordship, here I'm appearing on behalf of the, in item number 13, on behalf of the leading counsel,
Okay.
who's from Kolkata, your lordship. Lordship, today has some personal difficulty today, your lordship. So I pray that if this matter may come up next week, your lordship.
Oh, this will go after vacation.
No, 13, lordship. Lordship, next week, Your Lordship.
No, after vacation goes.
Tuesday date after vacation. 22nd,
Yes.
Mr.
Medovero.
Miro Learned Council has submitted that the leading council has partial difficulty today to argue the cases and has therefore sought listing of the cases on 22nd January 2025.
Lordship.
Mr. N. Mojui, Learned Standing Council, held.
Yes, Lordship.
Held.
No, Lordship, the board, Ayurvedic board.
Okay.
Sorry, Homeopathic board, Lordship.
Learned Council appearing for the respondent, Ayurvedic board authorities has.
Lordship, Homeopathic board, not
Homeopathic.
Ayurvedic, Homeopathic board, Lordship. My apology.
Has submitted that he has no objection to the prayer. Lays the cases accordingly on.
My lord, I'm the counsel for the item 14 and 15 for the appellant. My presence may also be reflected.
Okay. So his name is Medovero is item number 13. Mr. Pakin Richavu, Learned Counsel for Appellants in item 14 and item 15 is in attendance and has no objection to the prayer made on behalf of the Learned Counsel for the Appellant in item 13.
Obliged, Lordship.
Please, Lordships. I would like to mention item number 16, hearing item number 16. Since my senior is on leave, if this matter can kindly come up after the vacation.
On the prayer of Mr.
Donato Yepto.
Learned Counsel for the Appellant.
I'm appearing on behalf of Mr. Joshua Shekhi.
Learned Counsel representing Mr. Joshua Sheki, Learned Counsel for the Appellant, lays the case on a date immediately after the entering summer vacation, as it is submitted that consent has been taken from the learned public prosecutor to make the prayer.
Much obliged.
Much obliged.
Say,
My lord, I'm appearing on behalf of additional AG.
learned public prosecutor.
I place your lordships. Lordships, I beg to mention hearing item 10, 11, 12, lordships. Lordship, we have a consensus prayer if this matter can come up after vacation, lordships.
Consensus prayer, okay. Mr.
V. Koza, lordship.
V. Koja, Learned Counsel for the Appellants, and
Lordship, I'm appearing for respondent number 2, 4, and 5. I Jamir.
Learned Counsel for the respondent number 2, 4, and 5 have made a conjoint prayer to release the cases after the ensuing winter vacation. Mr. E. Thibapom, Learned State Council, is also in attendance. In view of the conjoint prayer made by the Learned Counsel for the parties, release the cases immediately after the
29, Your Lordship.
29.
29.
29. 1, 2025.
Obliged, Lordship.
Much obliged.
For motion, item number 1.
Yes, state. Get the records and file
Lord.
it by next week. We'll take up on Wednesday.
Lordship.
She is not on bail. Never made a prayer for bail till date.
Lordship.
Yes, Lordship.
But Mr.
I am Chen, your lordship.
I am Shil Learned Counsel for the petitioner and Mr. N.
DG Momi.
V. Momi, Learned Public Prosecutor. Nagaland for the respondent number 1 and 2.
1.
Where is Mr. Anguli? The present petition is preferred to a sale. An order dated 29/8/2024 passed by the respondent number 2 in exercise of powers under section 3 within bracket 1 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, whereby the petitioner has been detained for a period of 3 months. Whereas learned counsel for the petitioner has submitted that the impugned detention order is not sustainable. For
Mr. Counsel, who is the detainee?
Is the petitioner, Your Lordship.
Then how can he file an affidavit? If he's in detention?
Your Lordship, we have went to the jail and obtained the certificates and everything, the
Then
signature
how can that be?
from the jailer.
He has to swear this affidavit before whom?
In front of the
Can
jailer.
the detainee swear the affidavit before a notary public or before anybody?
he has to be present, she has to be present before the notary public.
Since he could not be,
That cannot be as per the Notary Act. Proper procedure is to get a Ukalandama to the jailor, then
Yes.
thereafter by the family member. Affidavit is to be sworn by the family member, one of the affidavits.
in that case, I may be allowed to withdraw and then file a fresh application, Your Lordship.
Fine. At the earliest, it is Mr. I. Chen, and counsel for the petition submitted that due to certain defects, he may be allowed to withdraw the writ petition with the liberty to file a fresh. Mr. Jimo, learned additional allotted public prosecutor has submitted that he has no objection to the prayer for withdrawal with liberty. In lieu of the above submission made by Mr. Imchen, learned counsel for the petitioner, this petition stands dismissed on withdrawal, with the liberty, as paid for.
Much obliged, Your Lordship.
From the supplementary cost list for motion, item number 20.
Yes, Mr. Jimami.
Lordship, I have no objection.
Heard. Mr. I. Apok Ponjaner,
Yes, Lordship.
learned counsel for the applicant. And Mr. P. Jimomi, learned state counsel for all the respondents. The instant application under section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 10 days in preferring the accompanying writ appeal. The accompanying writ appeal is preferred against a judgment and order dated 22/10/2024, passed by the single judge in a writ petition WBC number 175/2023. Where we have gone through the statements and averments made in the instant application, more particularly, paragraph 3 and 5 thereof. Mr. Jimomi, learned state counsel, has submitted that the state respondents will have no objection if the period of delay of 10 days is condoned in order to hear the accompanying writ appeal on merits. So we are also, having gone through the statements and averments made in this instant application, we are of the privacy view that the applicant has been able to make out a privacy case showing sufficient cause for condonation of delay of 10 days. So it is a The instant application stands accordingly allowed. The registry to list the bill for admission. We can hear the bill. Since it is numbered
Yes, Lord.
for admission.
Yes, Lord.
Yes, what is the case?
The main ground in the writ petition was that there was a gap in my service during 1990, 3 months period.
Gap.
There was a break or gap. Then after that, I was regularized. So my prayer in the writ petition was for regulars, since my pension should be, subordination should be counted from the date 1998, when I was actually regularized. Lordship, in the alternative, the prayer was that for after the break of 3 months in 1990, my service should be counted from 1990 onwards. There was one prayer, but this aspect of the prayer was not properly adjudicated by the learned single judge. And secondly, Lordship, the learned single judge had placed reliance on the judgment of the learned single judge as well as the division bench in WBC 270 of 2011 in the writ appeal. These were batches of writ petitions in appeal.
So prior to your regularization,
I was, yes.
you were what?
Lordship,
Ad hoc?
I was appointed on contract initially in the year 1988.
Okay.
Then I continued by the strength of.
So you stood superannuated on the basis of 35 years of service?
Yes, Lordship.
And that period was counted?
Yes.
Your contract
Initial
period was
appointment-
counted?
Yes, that was counted, and then I was sent on the alleged completion of 35 years of service.
But for pensionary benefit, only the regularization period has been counted.
No, Lordship, from 88, everything was counted.
Now, what is your prayer?
Now, Lordship, my prayer in the writ petition was that I should not have been retired from service. I was prematurely
Okay,
retired.
okay. Public Employment Act.
Yes. That-
Heard Mr. I. Apo Congener, learned counsel for the appellant. And Mr. V. G. Momi, learned state counsel for all the respondents. This intercourt appeal is preferred against the judgment and order dated
2210.
22/10/2024 passed by the learned single judge in WPC number 175/2023. Having heard the learned counsel for the parties, the writ bill is admitted. Issue notice return in 4 weeks. As Mr. J. Momi, learned state counsel, has appeared and accepted notice on behalf of all the respondents. Issuance of formal notice stands dispensed with. Learned counsel for the appellant shall, however, furnish requisite number of extra copies of the writ appeal along with an excerpt to Mr. J. Momi within 3 working days from today.
Within 3 days, Lordship.
3 working days.
Yes. Lordship, otherwise I wanted to place one document which was not readily available.
Bring it by additional affidavit.
Obliged. Obliged, Lordship.
For admission, item number 6.
Yes.
My lord, petitioner has been working as night janitor since 1st April 2011. Then vacancy arose in Oakland. I applied, which was not considered. But instead of
forwarding, my name forwarding as number one in the, among the fixed dates to the government by the director. A fresh candidate who was also forwarded along with my case, a fresh candidate was approved and appointed.
His appointment has been cancelled by Lawrence Vijay.
My lord.
He is
Then-
not preferring appeal. He is not preferring appeal.
No.
Oh.
Then
Yes.
second round was to pay me the scale of day,
Okay, that can be done.
my lord.
But so far as the post is concerned,
Yes,
Lawrence Single Judge has directed that open advertisement should be.
yes, yes.
Are you challenging that part of the order also? Come to
Page 134.
paragraph 29 and 30. And 31 also. 31 is specifically for you.
Yes. For that particular point, my lord, I may be allowed to take your lordship to page
So
25,
there are three parts to it.
my lord.
One is setting aside of the appointment of the private respondent.
Right,
You are not agreed. Next direction is to publish an open advertisement.
my lord.
Are you agreed?
Yes. First, the case of the petitioner should be considered under the scheme, that is office memo.
Now what is the IFO?
But you have only done 11 years of service.
Yes,
How are you going to be considered in terms with both the office memo? You are coming under the 2014 one?
Four.
2004?
my lord. In government also came up with the same memo, where it is said that 50% arising in a year.
No, that is 50% arising in a year
In a year, my lord.
for regularization.
Yes,
But that should be by maintaining a seniority list.
my lord. When I was recommended, my seniority is shown as number one. When forwarded by the director. So going by the memo,
Where is the office memo?
like 2015 in 4 is page 65.
Mr. Muajami, yes, then I delivered one judgment, remember? Where the Advocate General was appearing
Lordship.
in your case, na?
Yes, Lordship.
Where is the judgment? Because there I have taken care of these two office memorandums, na?
Lordship.
Yes, your lordship, it is here. Paragraph 29. No, I know the reader, so yeah, what do you mean? Paragraph 13, clear that out. I know.
No, not this one. Yes, Your Lordship. There's another one. Recently, I delivered.
That was pertaining to the City Rio's case.
So there, the both were questions I,
Lordship,
by
yes.
common judgment, I've
Whether
delivered.
2004 as well as 2015.
2004 and 2015.
Yes, yes.
So there the state stand, as per the Advocate General, who made the submission here. 2004 continues, 2015 continues.
Lordship.
2004 is against when there is an availability of vacancy,
Lordship.
and the vacancy would be filled up in accordance with the ratio which is being mentioned therein.
Lordship.
Whereas the 2015 is a case wherein irrespective of vacancy arise or not, that is not the question. What is considered is he has completed 30 years of service
Scale of pay.
in a scale of pay.
Lordship.
So this is how it is.
Lordship.
Here the question of scale of pay does not arise.
Lordship.
Hello, Mr. Counsel.
My lord.
There are four prayers. There were four prayers. Come to the first page of the judgment. One is administrative approval for appointment of private respondent.
My lord.
And second prayer is her order of appointment.
My lord.
Those two are challenged.
Yes.
Those two are set aside,
Yes.
right?
Yes.
Now, prayer 3 is grant of scale of pay,
My lord.
and prayer 4 is regularization. So I think as part of office memorandum, if I remember, one has to have scale of pay before regularization. But he's from which year? Your original appointment is when?
27 March with effect from 1st April. Appointment notice page 42, my lord.
Where is the notification of 2004?
2004, that is
Yes.
page 65. Government affidavit is at page 81, the same memo, he produced it.
But these are all work service.
Small Roman 3, my
You are
lord.
work charge.
No.
Fixed pay.
Fixed pay, contingency pay.
You are not work charge. Then
Not
how do you
work
come
charge.
under the 2004?
My lord,
The council, your whole prayer was on the basis of that Supreme Court judgment, perhaps, that scale of pay.
my lord,
Jagjit Singh,
my
that
lord,
was your submission.
my
Court
lord,
under single judge, that grant me scale of pay
my lord,
in terms of Jagjit Singh.
yes.
So do
Then,
not come under 2004 office memorandum. That is specifically for work charge.
Jagjit Singh applies to the fixed pay also.
No, for
That is what-
granting scale of pay,
My
the
lord,
minimum. That was the principle laid down.
my lord,
Jagjit Singh.
yes,
And you asked for scale of pay
yes,
first, because I think the office memorandum 2022 makes those persons eligible for regularization who have scale of pay. Is it not? Where is the 2022 OM? Huh? Ah. Hmm. So what is the principle for scale of pay?
My lord,
To be eligible for scale of pay.
yes, I understand that.
Neither 2004 OM nor 2015 OM has laid down any principle.
No, it is for regularization.
And what does
2004 is work charge, 15 is work charge in casual. Then Justice Singh, my lord, I may be allowed to take your lordship to my writ petition, para 2, page 25. That by office order dated 16/3/2011, the petitioner was appointed in the post of night chowkidar grade 4 and fixed pay of rupees 3,000 with effect from 1/4/2011 for a period of 3 months, which was extended all along. Last extension is up to 30/12/2022 by office order dated 14/4/2021, where he is continuing. The post of night chowkidar being full-time service, petitioner has been working on full-time basis all along. From the date of initial appointment, that is with effect from 1/4/2011, is continuing on contingency basis without interruption till date. It may be put on record that from the initial appointment, that is with effect from 1/4/2011 till date, the petitioner is the lone night chowkidar in the Directorate of Science and Technology, Nagaland, Kohima. My lord, the government affidavit, I may be allowed to take your lordship to page 72. That para is replied with para 4. That with regard to the statements made in paragraph 2 in 2.1. Of the writ petition, that the deponent respectfully submits that the petitioner such and such was appointed to the post of night chowkidar and fixed pay with effect from such and such for a period of 3 months.
now how do
But his service has been extended on humanitarian ground. You are not saying that I am the lone night chowkidar. It is not denied.
now how the
So
learned
I
single
don't-
judge has dealt with the issue? How the learned single judge has dealt with the issue? How the learned single judge has dealt with the issue?
My lord,
Ah.
it says that I have not played it as per 42 of Justice Singh, para 42. This is the reason I've given already. They have not denied it. Page 25, 2.1. That it may be put on record that from the beginning of January 2011, There was no night together in the construction site of the Directorate of Science and Technology complex. As such, the petitioner who used to work as a daily wager has been tasked the duty of night together from the beginning of January 2011 at the construction site.
One thing more.
What I
One
book,
thing more.
my lord,
By-
when it is not refuted by the respondent,
But
it's a admitted
one
fact.
thing more. Learned single judge has directed for publication of an advertisement
My lord,
to fill up the vacancy, permanent vacancy of night chowkidar, right?
my lord,
Then if the post is filled up by
it's not night together. The vacancy is a sweeper,
vacancy sweeper,
my lord. Now redesignated as multitasking staff. So I'm a fourth grade. The other vacancy also is
this
fourth grade
multitasking staff
staff.
concept has come from which time?
My lord, it starts from the central services.
What does a multitasking staff do?
My lord,
It works as a chowkidar as well as
yes,
sweeper.
yes. They can be assigned where it is required.
No, how many posts are there in the establishment? How many posts are there? If the post is filled up, whether your engagement will come to an end.
My position is
Because I'm asking
yes,
this question because of your IA. You are seeking stay on the advertisement,
my lord.
which implies that if the post is filled up, your engagement is coming to an end.
That is
Otherwise, why
that
is
is
apprehension?
most obvious. When it is a multitasking staff, all the four grade are now designated as multitasking staff. Sweeper is a sanction post. So tomorrow, any of the four grade staff can be deployed as night together. Earlier, all the four grade you were designated.
Now, fourth grade staffs are known as what nowadays?
Multitasking staff,
Staff.
my lord.
So there is how many vacancies in the establishment?
Now the question is this is the only vacancy.
Mr. Counsel, are you still working?
My lord, because
Which-
of this court order.
Huh?
Because of this court order.
No, prior to that? You see,
I've been continuing all along.
your period ended on 30/12/2022.
My lord,
Thereafter, the respondent number 5 was appointed.
my lord,
You have challenged it.
my lord.
Who was working then till the decision was passed by the learned single judge? Who was working during
No one was.
So no one was working. Now you are working on the basis of an interim order.
Interim order in where? Because in the writ appeal, what do you notice? What is your prayer in this IA?
My lord, I prayed for stay of that advertisement.
Yes, you are,
I'm for the private respondent, your lordship,
you
respond.
are not challenging,
No, I am not,
then
your lordship, the
you are
only.
a formal party now.
Yes, by virtue of this honorable court's order, I'm continuing in the service.
Who?
I am, your lordship.
Respondent number.
Yes,
Huh?
I am the respondent number. Yes,
Why? Your appointment was set aside.
it was set aside now till advertisement and filling up of the post. Yes,
This is somewhere something very interesting, my lord. Page 97 was a stay of this honorable court.
Huh?
Page 97,
paragraph 30, your lordship.
90?
97, annexure 6.
No.
Respondent 5 appointment was stayed,
Yes,
and it was revived by the final judgment order. Silakan. 97 state.
Huh? 90?
97, yes. Order dated 11/11 of 2022.
No, that was, this is repetition number 81 of 2022.
Yes.
That has been disposed of.
yes,
No.
By setting aside the appointment.
yes, your lordship.
My
of
lord.
private respondent.
Yes,
So status quo should mean that private respondent should be out of service. And both should be out of service.
your lordship.
That should be the interpretation.
You-
Because while issuing notice in the writ appeal, no stay was granted,
Your lordship.
meaning that you are out of service because the judgment takes effect. There is no separate order required to be passed
Your lordship.
for you to be out of employment.
Lordship, this is the conundrum in the case, but the problem, your lordship, is that he is seeking regularization against the post. The judgment which I have submitted, it is very clear he has no right for regularization against the post because he is a contingency employee, but he is still continuing.
And you
Now,
also-
as per the judgment, yes, as per this judgment, as per the judgment, the honorable single bench directed that I should continue until it is filled up.
Where?
Paragraph 30. Paragraph 30, your lordship, page 134, it starts. 134 page. Paragraph 30, the last line.
Yes.
Till such
Till
time.
such time. Now the post has been advertised and the interview was scheduled to be conducted last week. But because of the, again, interim order passed by this honorable court in this case, read up here. That.
Yes, anything to more to say? We are hearing the writ appeal itself.
So if my submission in the writ petition para 2 in 2.1, which is not refuted by the government side, I should be given the scale up payment. That is my main,
There has to be
Trust.
consistent yardstick
my lord.
to be granted the scale of pay to an employee. Has it been followed by the state? You cannot ask for a scale of pay by merely asking it. without showing any kind of yardstick.
My lord, my contention from the first read petition is that the person has been working.
But yours,
Of course, it was from January 2011. He was tasked. Now the directorate is functioning there, but it was under construction. So he was working there as a daily wager. In order to protect all that materials, he was tasked to stay there in the work site since January 2011. Yes, effective order of appointment is from 1st April 2011. Of course, fixed
you
pay.
were working as on date. You were working as on date.
Yes, my lord.
You were working, he's working, both working.
Yes. That is why.
You are working in some other post.
No, the same boss from the day one.
You were not granted an extension beyond 30/11 to 30/12 2012 22.
21 or 22.
Then how are you working?
No. Continuation has been given.
Huh? How are you continuing?
After this honorable court order, Nelson Nakato, Imanasi.
Because that is a specific case of you at paragraph 2 and paragraph 2.1, that it has not been extended beyond 30/12/2022. Then how are you working?
My lord, sir, 117. 117 because of this honorable court order.
117.
117, nature 8.
But as on this order was on 29/3/2023.
My lord,
And as on that date, you were already ousted from service.
no,
Yes. It is your case that there was no extension beyond 30/12/2022.
my lord, the petitioner being
No,
alone not to be done.
Come to page 119. Two para above it. Considering the above position and the submission made by the learned counsel for the parties, it is hereby directed that the petitioner should not be ousted from his post till the final disposal of the writ petition.
My lord,
So the writ petition was disposed of on 29/7/2024.
my lord,
So since you were on fixed pay by different orders, whether thereafter anything was ordered for your extension?
my lord, I have not no information, but the petitioner is still continuing. That is from official appointment 1/4/2011. Guilty.
You were said 2011. Because of this order, you are not to be ousted till the final disposal of the writ petition.
My lord,
And thereafter, in the writ petition, the writ petition was dismissed.
my lord,
And respondent number 5 was allowed till the vacancy is filled up.
my lord,
Meaning thereby, you are out.
my lord.
Impliedly.
No, it's sweeper. The petitioner holding is, of course, grade 4, which is night guitar. But It's a four-grade post. That is the only difference.
Okay, then we'll take up this for final disposal on Monday. Be prepared, not on IA. Not on IA, the whole writ appeal.
My lord. Yes, yeah.
So against one post, both are continuing.
No, these are
No.
different posts.
Different posts.
Yes. What?
Oh, now everything is multitasking.
Yes.
Yes.
Every post is named
Putting
multitasking.
in that
Not-
perspective.
No longer
yes.
chowkidar, no longer sweeper.
No.
Yes.
Everybody is multitasking
Yes.
staff.
Yes.
And Miss State Council, please take the instruction. They are working against which one? On the next date. He was night chowkidar, he is sweeper, and the post is redesignated as multitasking staff,
Yes.
and they are getting salaries against whom? Both are, you are very benevolent. Heart. Mr. I. Apo Congener.
I empty long
Oh.
time.
Ilongcha. And Mr.
Tongbok owner.
Kongpok Congener. For the respondent number 5. For the appellant and respondent number 5. Also heard him as Mary Learned State Council. Also having heard the Learned Council for the parties, it is deemed appropriate that the writ petition should be finally heard. As agreed to by the Learned Council for the parties, leave the case appeal on Monday
Much obliged.
for final consideration.
For admission, item number 7.
May it please your lordships. Lordships, here, my senior Mr. Ejimomi, the amicus in this PIL, my lords, he had to go out of station. He's traveling to Darjeeling for his son's educational purposes, my lord. So he tenders his apology for not being able to be present here today, my lord.
Why it has come?
Lordship,
I think
I may be-
by order, we allowed on 14 that new contractor.
yes, my
Steps
lord.
should be taken. Is it not?
Thereafter, Lordship, on 15/11, Lordship, this honorable court has directed to file an affidavit by the authority engineer as well as the NHLDC Lordship, which I filed on 26/11, Lordship. Lordship, there are two contractions on the field, Lordship, as per the short-term maintenance, Lordship. The United was floated and we have issued LOA, Lordship, and both are on the field. One will complete by this December, Lordship, and the second contract will complete by.
No one is for maintenance.
Both are for maintenance, short-term maintenance. For the entire straight road, it is 18 kilometers in total, Lordship. One is 8 kilometers and the other one is 18 kilometers.
Both are maintenance or?
Both are maintained. Both are for maintenance, Lordship.
No, what about the construction?
Lordship, as in terms of, in respect of the construction, we have filed an affidavit, Lordship, on 26, explaining what are the steps we are contemplating to take, Lordship. We have filed.
NIT
on
floated
26.
or not?
No, Lordship. We have categorically stated that once the short-term maintenance comes to an end, Lordship, we will evaluate, Lordship. The authority engineer has also filed the affidavit, Lordship, stating that we may take some time to evaluate once the short-term maintenance is over, Lordship. And also the timeline as to what are the steps we are contemplating to take, Lordship.
Has the affidavit been filed pursuant to the order dated 13/11?
Yes,
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 madam.
yes. I filed it on 26.
Affidavits.
At this stage, there is no urgency, Lordship, because maintenance works are being executed by the two contractors, Lordship.
Lordship, however, if I may take your lordships to the affidavit filed by the respondent number 2 and 8 on the 26th of 11, 26 November
Let us have
2024.
the
Yes, my
affidavit
lord.
with us. দেখি দিব কোনটো এইটো।
So you propose now to float a tender
Lordship.
as per this
Lordship.
paragraph number 6.
Tenders will be floated once the short-term maintenance contract comes to an end, Lordship.
Short-term maintenance contracts are up to
The one is
29
December.
December.
Yes, Lordship. And the second is 28th of January 2025. And there is also DLP for 6 months each, Lordship, for both the contracts, Lordship. So both will maintain till 28th June and
But
27 July.
when your tender will be floated?
Lordship, as per my affidavit, Lordship, tenders will, all this will complete by 27th of July 2025, Lordship.
How is the road condition now?
Lordship, the authority engineers here,
You are the amicus.
Lordship, maintenance is going on. However, Lordship, people are still facing problems to apply to the road, my lord. So my concern is, my lord, as per the affidavit filed by the NHIDCL, as per the paragraph 6, they have stated that the project will be completed by July 2026, my lord. So that is too long, my lord. So if that can be reconsidered again, my lord, that is my only prayer.
26.
Yes, my lord, July 2026. As per the earlier timelines which were given, lordship, the project was supposed to be completed by 30 May 2023. So that is another extension of 3 years, my lord. Of course, we are aware of the problems faced by the authorities, my lord, but however, the road is, we are more concerned about the welfare of the people, also the problems faced by the people, my lord.
So earlier contractor said that he completed 74.23%.
Lordship. Lordship.
And this maintenance is about that 74.323%.
Yes, Lordship.
Only that portion.
Yes, Lordship.
So other parties left
Yes, that,
unattended.
Lordship, the balance work will be executed by a new contractor.
What is the
Lordship.
total length? Total length of the highway?
26 kilometers, Lordship.
26.
Lordship.
The other earlier contractor completed 74%.
Lordship.
Meaning thereby how much? 18.
Lordship.
18. About
Close,
18.
close, yeah, approximately 18.
And this two short-term maintenance.
Lordship,
contract
but
is for which one?
Lordship, the earlier contractor has executed on the entire stretch of road, Lordship. But it is just that few items were incomplete.
No, your affidavit says
Yes, Lordship.
we recorded physical progress of the work is 74.23%
Yes,
as
Lordship.
on 28/8/2024.
Lordship.
Earlier contractor.
Lordship.
26 kilometer is a total length.
Yes, Lordship.
Then earlier contractor completed 74%.
Lordship.
Meaning thereby how many kilometers?
Lordship, the difficulty is, Lordship, the earlier contractor has executed on the entire stretch of road. It's just that a few items were incomplete, Lordship. And in addition to that, Lordship,
And this maintenance work is related to which one?
related
Entire.
to the earlier contractor, whichever he has
Whatever he
executed,
has done.
it is repair and maintenance of the work executed by the earlier contractor, Lordship. And another aspect, Lordship, if your Lordship may kindly consider, Lordship,
Now,
there-
what the new contractor will do?
there are some, the
Patches.
balance, yes, Lordship, in patches, as well as some additional item of works, Lordship. In 9 locations, the engineers, they have identified 9 different sinking areas, Lordship. That will be additional work. In addition to that, Lordship, 4 breaches, Lordship. That will be new for the new contractor, which will be appointed in pursuant to the NIT's, Lordship. So considering all those aspects,
When a
Lordship.
tender is likely to be floated after the defect liability period, you can start the process before that.
Lordship, once the short-term maintenance comes, it's completed, we will start with the process. I've also stated in my paragraph 4, 5, and 6, Lordship, the procedures, it will go till the headquarters as well as the mode that the ministry will approve, especially it involves financial implications, Lordship. And also we have to evaluate, the authority engineer on the field will evaluate and submit its report as to the item of work that is left for the balance work, Lordship, as well as the new additional works which we are proposing to hand it over to the new contractor, Lordship.
But here the defect liability period
Lordship,
is for the maintenance.
Lordship, yes, Lord, maintenance.
That maintenance is only in respect to certain areas which have been completed.
Lordship, yes, Lordship.
You don't maintain anything which has not been done.
Exactly, yes,
Because
Lordship.
your submission was
I agree, Lordship.
that though he has done 74%, but
Lordship.
certain areas were not done.
Lordship,
And therefore, he did it for the entire stretch of 26
Lordship.
kilometers. But certain, just for example, a bridge
Yes,
was supposed to be made, he did not make it.
Lordship,
So obviously, in that bridge, the question of maintenance does not arise.
Lordship.
So why there is a delay for the purpose of going for a fresh tender in respect to that? Where is the question of assessment to be made in respect to those areas where there's been no work at all?
Lordship, assessment will be only pertaining to those stretches of road onto the 26 kilometer, but the 9 sinking areas, these are something new, Lordship, which has occurred, Lordship, in the process of executing, Lordship, and it has not been touched by the earlier contractor, Lordship. And also 4 bridges that was not part of the earlier contract, Lordship. We have identified, and we are proposing to include it in the new contract, Lordship.
But you also have a particular provision in the contract which you
Lord.
had with the earlier contractor.
Lordship.
That if you don't complete the work within a particular period of time, you can very well do so at the risk of the contractor.
Lordship. And which is why we have floated these 2 tenders at the recent cost of the contract for this short-term maintenance, Lordship. This is a part of the contract agreement.
Maintenance can only happen in respect of a work completed. There
Lordship.
cannot be a maintenance of
Whatever
a thing which
the-
has not been done or half done.
Yes, Lordship,
How
whatever
can you
the,
maintain something, if a road has been, requires a WRB or whatever WBM and all, which has not been laid.
Lordship.
There's only the gravel. You
Lordship.
can maintain that.
Madam. Heart, Miss
It's Lucino, my lord.
Lucino, you just give the number, responding number and name.
Lordship,
Right.
Lordship, we'll do that, Lordship.
To the
Lordship, my Lordship.
Mr. Moaz Jomesh, Learned Counsel, appearing for the respondent NHIDCL authorities have submitted that pursuant to the order dated 13/3/2024, he has submitted an affidavit of compliance on 26/11/2024 by furnishing copies to the learned amicus curiae and other learned counsel for the other respondents, full stop. The said affidavit of compliance is on record, full stop. Whereas from the said affidavit, it transfers that on two short-term maintenance contracts were awarded on 25/10/2024 for two stretches of the road. Here it is, with contract duration and defect liability periods, different contract duration and different defect liability periods respectively, and the same as under. You quote paragraph 2. Okay. It has been averred that assessment of the balance work for the entire stretch can only be accurately determined after the completion of the above two contracts post 28/1/2025. Full stop. The respondent NHIDCL authorities in paragraph 4, 5, and 6 have averred as under. To extract 4, 5, and 6. As the assessment of the balance work is likely to commence after 28/1/2025, release the case on 1st of 3rd of February, 3rd of February, to enable Mr. Moajami Lanet, counsel for the NHIDCL, to 5th, okay, 5th.
Lordship.
The status, the steps taken for assessment of the balance works.
Lordship.
Show us that you are taking these steps.
Lordship.
My lord.
MS Lucino.
Yes, my lord.
Shall obtain shall submit as regards the conditions of the road which are to be maintained during the said period up to 28 January.
Much obliged.
For orders, item number 9.
May it please your lordship, I am appearing through VC, my lord. This is with regard to a suo motu matter that was taken up and that was disposed of by this honorable court, transferring a criminal trial from Mukuksang to Kohima, my lord. Right order dated 16/10/2024, my lord. Now, after this honorable court's order, all the record has been brought to and been produced before the learned district judge in Kohima, my lord. My lord, will kindly take up the IA. There is an order that has been
Mr. Bhuya,
Yes, my lord.
what a kind of modification you are seeking?
My lord, as because my lord will kindly see
Because
the
of the,
IA
because of the situation occurred subsequently, right?
Yes. No, not like that, my lord. My lord, this honorable court was pleased to hear the matter at length. All the parties has been heard, and even the accused persons were made a party. And thereafter, because of the security threat that time and thereafter, the matter has been transferred from Mukukchung to Kohima district, my lord.
Mr. Bhuya,
Now the
because of the recusal,
yes,
because of the recusal of the learned session judge,
yes,
this IA is required to be filed.
yes, my lord,
Has
to bring
arisen-
on,
Situation has arisen to file this IA because of
yes.
recusal of the learned session judge.
Yes, because one of the family members, yes, my lord, that's the, to
So-
apprise this honorable court, because there is a time frame
Right.
wherein within 12 months, the trial has to be over. Now,
Mr. Guya, we have to consider view that
yes,
it should be taken up by the appropriate bands.
I leave it to your lordship discretion, man. Yes, man.
Registry. As this interlocutory application has arisen out of a judgment judgment and order dated 16/12/2024.
Yeah.
Passed by division bench in TRP Somoto 4/2023. Registry to list this I before the appropriate bench.
Deeply obliged, deeply obliged.
for motion, item number 1.
Yes.
Okay, this instance, the petition is filed for appointment on competitive law. Your Lordship, the brief state of affairs is that the petitioner's father led Long Hong died harnessed on 30/05/2021 while rendering service SPO under the establishment of sub treasury office department,
No.
leaving behind his wife and five siblings. Lordship, to the untimely demise of the petitioner's father, all the burden falls upon the mother, who is also unemployed, and there was no source of income. Lordship, upon the demise of the petitioner's father, the petitioners submitted a representation for appointment on compassionate ground on the state memorandum 17/09/2015, Lordship. And as for the office memorandum, it is clearly stated that those government employed who died in harness while rendering service to the government, leaving behind their unemployed family members.
Okay, heard, Mr.
Not yet, no, Lordship.
Lakni Pom. Land Council for the petitioner and Mr. N. Long Kumar. M. Long Kumar. Learned junior government advocate for all the respondents. The case of the petitioner is that petitioner's father, Long Ni Fong, who was serving as a peon in the office, the sub-treasury office, Longling, died in harness on 30/05/2021, leaving behind his wife and 5 children, including the petitioner. Full stop. As a result of death of late Longni Hong, the family of late Longni Hong has been facing financial stringency as the petitioner's mother is also unemployed. So stop. Do you have, what kind of qualification you have?
Plus 12, Lordship, plus 12.
The petitioner where did you state?
Lordship,
No. The learned counsel for the petitioner has submitted that the petitioner has acquired the qualification of higher secondary. Full stop. Seeking her appointment on compassionate ground in terms of the policy of the state government notified by an office memorandum dated 17/9/2015, the petitioner submitted an application in the office of the respondent number 4, who in turn had forwarded the said application to the where is that forwarding letter?
page 20. Exactly.
By a letter to the office of the respondent number 2, by a letter dated 8/6/2021 within bracket annexure D at page 20. So stop as no, as the said as the application of the petitioner appears to have received no consideration, comma, the petitioner has approached this court by this said petition, full stop. As per the policy, as per the policy of the state government notified via the office memorandum dated 17/9/2015, comma, appointments on compassionate ground can be made to the post falling under the combined direct recruitment quota of Group C or Group D. Page 9 or paragraph 4. Up to a ceiling of 50% of the vacancies during a year. Full stop. Issue notice returnable on.
Yeah, please, Lordship. Lordship, it's been almost 3 years. It's been almost 3 years since the Lordship, after the representation was forwarded. It's been almost 3 years, Lordship. So if this matter will be disposed of.
Yesterday I said, Supreme Court has said, High Court should not take resort to disposal of representation business in case of compassionate appointment. Because by that time, after 2-3 years, they will come with a negative answer. By that time, 6 years will be gone by. Your case will be issue notice returnable. I'll make that observation so that they can come up the counter. Notice returnable on 22nd January 2025. As Mr. Longkumar has appeared and accepted notice on behalf of all the respondents, issuance of formal notice to the state respondents stands dispensed with. Extra copies within 3 working days. 1 minute.
Second January is Wednesday.
Oh, I'm sorry, 25.
And 5 would be a Saturday.
Okay. 24. Though a submission is made by the learned counsel for the petitioner that this petition can may be disposed of with a relation to the state respondents to consider the representation application stroke representation submitted by the petitioner, comma, the said submission is not accepted, at this stage, in view of the following observations of the Honorable Supreme Court of India in Government of India and another versus P. Venkatesh, reported in 2019, 15 SSC 613, right. Nine, 10, 11. Having regard to the facts of the case and the observations, the above observations, this court reserved the considered view that the state respondent should file its counter affidavit on or before the returnable date for consideration of the case of the petition. Place the case on 24.
For motion item number 2.
Same. Mr. Swainso for the petitioner, Mr. Ramkumar for all the respondents. Petitioner's husband, late T. Anie Fong, serving as office peon in the office of the Directorate of Municipal Affairs, Nagaland, died in harness on 24/12/2023, leaving behind the petitioner and 2 minor siblings. Subsequent to the date of her husband, the petitioner submitted an application on 9/5/2024, seeking her appointment on compassionate ground in terms of the policy framed by the state government and notified by the office memorandum dated 17/9/2015 against the vacancy created due to the death of her husband. The said application was duly forwarded by the Additional Director, Department of Municipal Affairs, Nagaland. Page. To the Commissioner and Secretary, Urban Development and Municipal Affairs, Nagaland, provide a letter dated 29/8/2024, annexer E at page 20. In response to the said letter, the Municipal Affairs Department, Government of Nagaland, by this letter dated 11/9/2024, sought information from the respondent number 4 as regards availability of vacancy in Group C and Group D. by its letter dated 11/9/2024. Full stop. As no information has been made available to the petitioner, thereafter, the petitioner has approached this court by this writ petition. 50% ceiling limited. Issue notice returnable on 24/1/2025. A P. Venkatesh. This is the case. As Mr. Longkumar has appeared accepted notice. Extra copies within so working days.
For motion, item number 3.
Yes.
There I'm selecting the appointment of this file number 6, who was appointed without conducting any selection process. The Lordship, the petitioner, who is one of the.
Landowner.
Yes, Lordship.
Landowner.
Yes, Lord.
Okay. Where is the appointment?
My Lord, that's page 20, Lordship. That will be the page 20, Lord.
January 2023.
Yes, Lord.
Why so much delay?
Lordship, page 21.
Did you make any claim earlier?
Yes, Lordship.
Your name is Peter Kant.
13. I made my application on.
Okay. Heard Mr.
Mr.
Nisuka Sichi, learned counsel for the petitioner. And Mr. M. Longkumar, learned junior government advocate for all the for the respondent number 1 to 5. Full stop. In this petition, the petitioner has assailed the appointment of the respondent number 5, 6. Who has been appointed in a post of multitasking staff. In the office of the respondent number 5 by an office order dated 13/1/2023 issued under the hand of the respondent number 3. Full stop. The petitioner has claimed that he submitted an application as a landowner for a said post. But
I don't hear the application was completed on completed ground.
Huh?
Completed ground.
Compassionate ground.
Yes, sir. My Lord, since the petitioner is disabled.
Okay.
Personally disabled.
Okay. The petitioner has claimed that he submitted an application in the year 2021 for consideration of his case before the respondent number. Engineering chief is what? 3. Page 19, right? Page 19.
Yes, sir.
Before the respondent number 3 in the year 2021 for consideration of his case for appointment against the same vacancy on the ground that You are descendant of that person, huh?
It's nothing. In support of that, million is certified as I'm one of the grade 17 units.
Huh?
Grade
Grade
17 in chairman. Criminal was executed in last night on 1960.
As a member of the landowners family. And his physical disability. It is a contention of the petitioner that ignoring the better claims of the petitioner, the respondent authorities had arbitrarily and illegally appointed the respondent of 6 without any kind of, without a publication of any advertisement and without any selection process. Issue notice returnable on 27/1/2025. As Mr. Longkumar has appeared accepted notice on behalf of the respondent number 125, issuance of formal notice to the said respondent stands dispensed with extra copies 3 working days. A petitioner shall take steps for service of notice upon the respondent number 6 by registered post with AD within 3 works.
As well as
Okay. As prayed for, the petitioner is also permitted to take steps for service of notice upon the respondent number 6 by way of dusty. It is provided that after serving and the routed through the registry, serving the police also compliance affidavit to that effect on or before the returning date.
For admission, item number 4.
Yes.
I think it's identical to the case which was listed yesterday,
अपनी मर्जी लेंगे item repetition number
42 after the forward. Yes.
Senti anger.
Instruction was given to, direction was given to seek instruction whether there will be a medical certificate. And I have spoken with the federal government similar to the also.
More chair.
Yes.
Okay.
We consent that similar order that we pass. This was passed yesterday.
What was observed? Nothing ordered.
On Friday.
Order to yesterday.
42 after the before I yesterday. I don't miss court number 1. Yes.
WC 42.
Then our parties is also same.
Same party.
Yes, the same party. Same department, same party, same millions.
Print out. Print out.
I checked last night.
Okay. I signed yesterday. Printer night. Oh, what could I do? Printer. What? Did you receive any part payment?
This, I received 11 lakhs 6,111 rupees.
So remaining amount is 20,81,889.
Yes, ma'am.
For 9 years, you are not getting anything.
No, ma'am.
Otherwise, limitation period is gone.
Yes, Lord.
That will not be of much help to you.
Yes, Lord. In fact, the minister has with the appointed the public is delighting it also.
But question is the forum.
Yes, Lord. That is there. And if,
They are not admitting anything.
yes, and if Lordship, the civil suit is preferred, Lordship, it may take years. And
But that is not the shortcut. Otherwise, if there is no admission of liability. Okay.
if the negotiation can be reached,
Okay, I'm giving you that opportunity.
my Lord.
Para 1 contract work. Change construction of cafeteria Jakpang.
Yes, Lord.
Provide a work order.
That is 10 to 2014.
Into page.
Annexure 2, my Lord,
Annexure 2.
page 11. That copy is at page 12.
Contract value 31.88 lakhs. They inaugurated it.
Yes, Lordship. By the Minister of Rural Development. On 18th of October 2017.
18th of October,
Yes, Lordship.
2017. Completion certificate not issued.
No, Lordship.
Okay, remaining amount is 20 lakh
81,800.
State as respondent, same kind of environment?
Yes, same department, Lordship. Same respondents.
Okay, simply.
Yes, Lordship.
The government of India dropped that
Yes, Lordship.
and not as per specification.
Yes, under the same ministry, sponsored by the same ministry.
By his sim. Only eligible, Mr. M. Long Kumar, Learned Counsel representing Mr. Moa Imchen, Learned State Council for all aspects. Learned State Council representing Mr. Moa Imchen, Learned State Council for all aspects. Okay. Friday.
For orders, item numbers 5 to 17.
For what service? Ah,
Item number 5, 6, and 7, not still available.
5, 6, 7. 251. 114. 252. In respect of 4 and 5. Respond number 4 and 5. You have heard a petitioner. Service reports in respect of respond number 4 and 5 in these 3 items. It is awaited. What to do? We have to wait.
I'm appearing in item number 8, 9, 10, and 15. I'm visiting the Nagaland University, spot number 4.
Okay.
Lordship, I'm the petitioner from item number 11 to 17.
11 to 17. Okay. You're Mr. Aijamir. Mr. Aijamir. Learned Counsel for the petitioners in item 11 to 17. And Mr. Learned Counsel for the petitioners in item 5 to 10. Mr. Muajam is Learned Counsel representing respondent Nagaland University. Huh? 4 and 5. Let us see item then.
Item number 8, 9, and 10.
1 minute. 4, 5, and 6. Just see. Four, 5. This is 4. 251. No, 250, 114. This is 114. This is 6. Okay. 253. Item 8. You said in items
8, 9, and 10.
no. In the
5, 6, and 7.
5, 6. WC 251. This one 251. Okay. And item number 7, 252. 252. Item number 6 again. Item number 6. Once again. 114. Item number. This is 5. Mr. Counsel, for item number 4, 5, and 6. Here, office note says that respondent number 4 and 5 await service report. this Mewar University, respondent number 4 and 5, Mewar University, right? In item WPC number 251 and 252. Respondent number 4 and 5 are Mewar University. Rajasthan. Now they have sent two affidavit in opposition by post. Now there is a office note. You go through it. Otherwise, they have received a notice. Read it. They have sent it by post, but as per our practice and procedure, it has to be filed in the filing section. So those two affidavits are not taken into account, meaning thereby they have been served. So what to do now? We cannot take notice of those statements and averments made in the affidavit, which is not properly filed. What to do? Think it over. Because it is not a case of await service. Right? They have received, they have prepared the affidavit, sent it by post, stating their side of the story. So think it over. What to do? It may be in your support also. You have go through it. If it is in support, then take the appropriate steps or apprise the court that this should be, they should be informed like that. So you think it over. How to, if it, you can read the affidavit, find out if it is in your support, then you come up with your appropriate submission on the next day. I think that will be better. Otherwise, prejudice might be caused to the petitioner. Since it is a, I think I have not seen a single word. It appears to be on the qualification issue, perhaps. Whether degree is valid or diploma is valid, that is the question, perhaps. So, Mewar University, they are giving their stand. You read it up and find out what will be the appropriate submission you should make on the next date. Okay? Mr. Moa Jamir, Learned Counsel for the respondent, Nagaland University. And Mr. M. Longkumar, Learned Junior Government Advocate, representing Mr. N. Angami, Learned Junior Government Advocate for Senior Government Advocate for the state respondents. Full stop. Mr. So-and-so Learned. Mr. Messiah Learned Counsel. For the petitioners in 5, 6, and 7. আগতে তো গোটেইখিনি কলো 5 পৰা 10 বুলি 5, 6, and 7. 5, no, we are concerned with 5, 6, and 7 now. Has, after having gone through the office notes, etc., has sought listing of the cases after a week in order to make further submissions. Post of list the cases accordingly after a week on a date to be fixed. The interim order. If any, in WPC number 114/2022, shall continue till the next date of this thing. You find out, you read the affidavit of Mayor University, then come up with appropriate submission because of the defect in filing, right? Then you may seek a direction from the court to intimate to the Mayor University that this is the procedure, send a letter from the registry. Or you can on your own inform, right? Huh? Mr. Akam. Spelling. Ah. Where? In the call list. Call list. Okay. The name of Mr. AKUM. Learned Counsel be reflected along with Mr. Moa Jamir for the respondent Nagaland University in the call list. So you think it over. First you read the affidavit. I'm giving you that opportunity. You read the affidavit, what they say in support or against you. Okay. Yes, who is appearing? Who is appearing in the PC? Somebody is appearing? In this case.
Hello. Hello, court officer. Hello. Hello. Hello.
Hello.
Court is over today, na?
Yes.
So can our case be listed next week?
Item number?
Item number 12. Sorry, 14th. Dr. Gautam Ghosh.
Item number?
Item number 14th. No, item number 13. 13, 14, 15 together. Could you fix it at the top of the list next week?
Oh, will be listed after a week.
Next week?
After a week.
Oh, please, can you help? I want to see the Hornbill Festival. If it is fixed on 11th, I'll come on 8th. Please do, I'll meet you.
It will be on 11.
Yeah. Hello, sir. 11th.